King on Appellant of Quaye against the Secretary of State for Justice.
Yes.
My Lord, I may have to borrow 10 minutes from my reply because I need to deal with the policy statement that I hope the court has that now.
Is this one of the documents that
Yes.
came in an email?
Yes.
I think I've got it. I'd better check with my colleagues.
We have copies, I think. We've got copies.
Could I have a copy?
This is the policy that applied between 2010 and 2014, and we've been told that the same policy applied in 2015. At least this is fairly detailed. And if I can take you to 10.7, that deals with the status of the policy. And one sees at 10.7.1 that following the House of Lords judgment, the Secretary of State is required to keep under review the tariffs of those sentenced before 30th of November, and then he has since decided to extend those arrangements to cover all HMP detainees irrespective of when they were sentenced. So that's the first point, that there was a decision, conscious decision, to extend it to all. Then secondly, it describes there that detainees who are approaching the halfway point of their tariff will be invited to confirm whether they wish to make representations, and then the views of staff will be taken. And then thirdly, at 10.7.3, if the PCCS staff consider the information is such as will meet the criteria, it will be submitted to a High Court judge. So that's a sifting process, and then finally it goes to the judge for the High Court judge to consider. And we know that the Secretary of State accepted the High Court judge's views, and indeed, my lords, my lady, you have at Annex A, page 736, a whole series of decisions, published decisions of judges revising the tariffs. So that was the policy. And we can see there's another passage which I should draw attention to. It's at 3.2.6, and there you can see.
Still in the policy.
Still in the so back, my lady, to 3.2.6. A little bit more detail there. It says detainees during Her Majesty's pleasure. The sentence of detention is a statutory penalty for a person who commits murder between the ages of 10 and 18. The offender's actual age at date of conviction is irrelevant. I think that must be describing the basis on which the sentence is imposed. Then it says that the prisoners seeking a tariff are entitled to apply, are entitled to periodic reviews of progress in custody with the possibility of reduction in tariff. So we stress the word entitlement there. Then there's a review to determine if the existing tariff is still appropriate. That echoes the language of Lord Bingham, I think at paragraph 12 of Smith, to determine whether it's still appropriate in the light of the detainee's progress. And then the eligibility, it starts at the halfway point. One sees that. Detainees become eligible for review once they've reached the halfway point. And then finally, reviews are not automatic. You're entitled to apply. You're entitled to, as it were, be monitored and to be considered, but it's not automatic. The test is, have you met, or may you well have met the criteria. So that's the position, and that's obviously the basis on which, in addition to the other materials I showed the court, including the letter that was sent to those approaching the halfway point, those are the bases for the legitimate expectation that we say was created in addition to our fundamental point that, in fact, this was owed to the prisoners because of the nature of their sentence in any event.
Is it accepted that that the policy changed in February 2021?
Yes.
And do we have a copy of how the policy changed in February 2020? Do we have a copy of that policy?
I'm not sure at the moment. I think we do.
Okay.
Yes, I think we do. Yes.
If we could have a pen.
Yes.
So is it accepted that the legitimate expectation changed as a result of the change in policy? Because the legitimate expectation would depend, to the extent that you rely on the policy being in place. But when it changes, that changes the nature of the expectation.
My lady, and that I accept that would be the case. But what we say is that because it was founded on a change in legitimate expectation can see Del Rio Prado amount to a change in the nature of the penalty. But in addition, of course, as my lady in the court know, our central submission is that the policy in fact reflected the rationale of the sentence for all those sentenced before or after 2000.
Yeah, which depends on it being intrinsic, that there was an ongoing review duty. That's
right. And that survives the 2000 Act. I was just on Del Rio Prado yesterday. Can I just finish that very briefly with the court? I was paragraph 103 of Del Rio Prado, which is at page 1646. As set out there, the original sentence to which remission applied was 30 years imprisonment, and any work done for remission would be deducted. And then at paragraph 106, they set out that he had earned remission under that, I think, 3,282 days. That's paragraph 106. Then under the new regime, as per paragraph 107 on page 1647, the initial sentence was, quote, limited to an effective term of 30 years, but the remissions of sentence previously earned were now to have no effect whatsoever. And
sorry, where are you reading from?
Paragraph 107.
107.
The applicant was initially sentenced to a number of lengthy terms of imprisonment, which are combined, limited to effective term, and then it ceases to have effect, meant to be had no effect whatsoever as a result of the change. And really the key passages are 108 to 109 for our purposes. They say, although the court agrees with the government that arrangements for granting adjustments...
Oh, well, sorry, just before we get to there, paragraph 107, the court notes the application of the Parrott doctrine to the applicant's situation. So that was the, in effect, change in the law, which ultimately was found to be in violation of Article 7. Deprived of any useful effect, the remissions of sentence for work done in detention to which he was entitled by law and in accordance with final decisions by the judges responsible for the execution of sentences. So that looks as though there was already a set of judicial decisions saying that there would be an entitlement to remission. Is that right?
Yes, and then there was a change in. They then said we got it wrong, and you're not entitled to remission.
Right. But that's a different pattern from what we've got here, because there's no judicial determination of entitlement to remission here. Well, it's just there's the Secretary of State's policy, but there's no judicial determination, is there?
No, my lord. Well, I suppose what you have is a whole series of judicial decisions founded on the understanding.
No, but this is looking at what you're entitled to ask for.
No, my lord.
Here, the only judicial intervention is setting the minimum term at the time of sentencing, which does not have written into it, and the minimum term will be defeasible if certain events happen in relation to the conduct of the prisoner.
My lord, I accept that decision.
Yes. All right, I just wanted to check.
My lord, I do. Can I? But if I can just try to indicate what we say we can rely on, is paragraph 108. That being so, although the court agrees with the government that arrangements for granting adjustments of sentence as such fall outside the scope of Article 7, considers the way in which the provisions of the Criminal Code were applied in the present case went beyond mere prison policy. So the test is, does it go beyond mere prison policy? And then one sees at 109, this measure taken by the court, that's to say the measure to reverse the earlier decisions. This is the penultimate sentence of 109. This measure taken by the court that convicted the appellant also led to the redefinition of the scope of the penalty imposed. As a result,
but doesn't that link in with what I was just putting to you about the nature of the judicial decisions identified in paragraph 107? As I understand it, what was happening in this case was that the judicial decisions themselves, so the sentence imposed by the judge, had built into it a scope for remission of that sentence.
Yes.
That's built into the sentence imposed by the judge themselves. That's why it's beyond mere prison policy when you change that, and why it means that the new approach led to the redefinition of the scope of the penalty imposed.
Yes, my lord, I think I have to accept that. My lord,
but I'm so sorry to press you on this, but it may be very important. But if you're accepting that, and you accept that our case is different because it's not the possibility of remission under the Secretary of State's review, which is passed on to a High Court judge for advice, but it is still the Secretary of State's review, that doesn't fit the pattern that's being talked about in these paragraphs in Del Rio Prado, does it?
well, my lord, I'm taking it at a slightly, I suppose, higher altitude, if I can put it that. There is a distinction made between whether a thing is a matter of mere prison policy or whether it involves the redefinition of the penalty. And
But that's where I'm drawing your attention to the fact that the court seems to, when it's talking about the penalty, seems to be talking about the sentence imposed by the judge.
Yes.
If there's a change in the sentence imposed by the judge.
Yes. Well, my lord, yes, and I understand.
All right.
My lord, all I can submit is this. When the judge imposes a sentence, the judge is in fact imposing a sentence against the background that it is a reducible sentence. And that follows from the reasoning in Smith applied to those sentenced after 2000. In other words, they are in effect sentenced to 15 years in this case, brackets, but that is reducible. And there is then there is a second layer, which is a policy to give effect to that on the basis of which they can say, you have a policy which gives rise in me to a legitimate expectation of this formalised, judicialised review of whether the sentence originally imposed is still appropriate. So it's not, and that's the language of Lord Bingham, paragraph 12, whether the sentence is still appropriate. And that, we say, also goes beyond the mere a matter of prison policy and becomes a redefinition of the scope of the penalty. And my Lord's Majesty, just applying that approach to the appellant's sentence, it's clear that the minimum term from the time that the appellant was sentenced until the policy change in 2021 been regarded as a reducible period, subject to revision downwards in the light of a review at the halfway point. That followed from the House of Lords' analysis in the nature of the sentence in Smith, and I'm obviously thinking of paragraph 11 of Lord Bingham saying it doesn't matter whether it's judicialised, and also Baroness Hale at paragraph 25 saying it doesn't matter whether it's judicialised. And the Home Secretary's policy giving effect to that interpretation. And then from at least 2010 onwards, it appears it's probably 2006, the time of his sentence, there was a formalised system of review in place whereby cases were referred to judges for consideration in accordance with published criteria, and judgments were given. You've seen one of them, Essel, at tab 68, pages 1577 following, but there is an annex at page 736 which sets out, these were all published judicial decisions So prisoners knew that there was available recourse eventually to a court to refix the sentence in the light of progress. And we say that that entitlement to review was communicated to prisoners who had reached the halfway point in the standard form letter that the court has seen in the annex to the appellant's case at page 72, which refers to the entitlement to have your case reviewed by a High Court judge in the light of progress you have made whilst in custody. So the language was entitlement, it was formalised, it went to judges, they held, not oral hearings, but they considered representations and made decisions. This, in our respectful submission...
And just on the word entitlement, I think you showed us from the policy that, in fact, there was a screening exercise carried out by officials before the matter would be referred on. So
it's not automatic.
It wasn't an entitlement. It was a process that was kept under the control of the Secretary of State via her officials. Is that
well, could I formulate it this way? You're entitled to be considered for a review, and if you meet the criteria, to have a review. In other words, there's a test. If you satisfy that test, or are considered that you may well meet that test, then you are entitled in that sense to a review. I mean, if it had been refused, though that's an extreme case where the person everybody agreed in made exceptional progress, the decision not to refer would be judicially reviewable.
Yes, I see. Now, Mr. Fitzgerald, just be aware that you are now eating into your reply time.
No, my lord, yes, absolutely.
Which will allow you to do, but
yes,
you should be aware.
Well, then, so this we say that there was a legitimate expectation his penalty would be reducible. The measure went beyond mere prison policy, and the Secretary of State himself accepts that the sentence of DHMP had been redefined and modified by the introduction of 27A11. In the words of Lord Bingham at paragraph 12, the new thing involved the formation of a more reliable judgment as to what punishment he actually deserved. And in relation to the test of foreseeability, which my Lord Stevens refers to in the case of Morgan, paragraphs 101 to 104, pages 992 to 993, we say it was certainly not foreseeable that the right would be removed by reference to the fact the date of sentence came shortly after the offender attained the age of 18. The only document says age is irrelevant, age at the time of sentence is irrelevant. So at the very least, there's a legitimate complaint the law was not sufficiently clear and this change was not foreseeable from the start.
Was that argument raised in the courts below?
About foreseeability?
Yep.
Yes, well, we certainly relied on the
Whereabouts in the judgments is it dealt with?
My lord, I can't locate it, but certainly the foreseeability point was raised. Yes, I think we can, my lord, we will locate it. Yeah. So then, just very briefly, the two cases which the court very helpfully drew to our attention, re-MA.
Forgive me, I'm not quite sure what point you're making about the law wasn't foreseeable. Is this an additional complaint leading to a finding of violation of one of the convention rights?
Yes.
Can you explain to me what this complaint is? I hadn't picked it up from your case.
I'd understood it to be a separate freestanding complaint about Article 5.
It is in Article 5, my lord.
Yes.
Yes.
Well, but I struggled to see where it was raised in the courts below.
In relation to Article 7, you mean, my lord?
No, Article 5. There was a breach of Article 5 because it wasn't foreseeable that the law would change.
Well, my lord, I will try and find the implication that we obviously have various...
In answer to my Lord Sale's question, what is the point that you're making?
Well, if you look at the Del Rio Prada, they do talk in terms of whether the thing was foreseeable in terms of Article 7.
Well, so we seem to be leaping between Article 5 and Article 7. That's why I just want to understand what the submission is.
I'm on Article 7.
All right.
And I'm dealing with foreseeability under Article 7. And my respectful submission is that the question of foreseeability was looked at in Del Rio Prada in the context of Article 7.
So to show us where the Strasbourg Court does that.
So, Del Rio Prada.
Yes, I'm looking at page 1647, if that helps you.
1647, yes.
But maybe you have another part of the judgment in mind.
Yes, my lord. The court must also consider case law. Yes. Well, at 99, they're talking about what the policy had been, page 1644. And they yes, yeah, paragraph 102, they're talking about continue to enjoy the benefits of the scheme if it was to their advantage. Yes, and then at 103, the situation that did apply, and they actually use the word legitimate expectation themselves. My lord, I think I referred to that.
Right.
Yes, so
I may have missed something, but scanning those paragraphs, it didn't seem to be put in terms of reasonable foreseeability and so on. It seemed to be put in terms of the definition of the sentence.
Well, one of the...
If you look at the end of paragraph 105,
yes,
the court reiterates that the principle embodied in Article 7 is that only the law can define a crime and prescribe a penalty. And then they go on to say, and in this case, the law had prescribed the relevant penalty in all the judicial decisions, but that was changed by, I think it was a judicial redefinition, in effect, of what the penalty would be. So that if that's right, that's got nothing to do with foreseeability as it occurs as a test in other areas of the convention. Anyway, we're looking to you for assistance, Mr.
Well, no, I understand.
Paragraph 111.
111.
1647, there's a heading.
Yes, paragraph 111, 1647, as to whether the change in the law was foreseeable. Yes.
But that,
yes.
in relation to foreseeability under Article 7 has got nothing to do with changes to the execution or enforcement of the penalties. It's a change to the scope of the penalty because criminal law develops. And so under Article 7, there is a degree of foreseeability. If you commit a crime on day 1 and are sentenced on day 60, that the criminal law might have changed. And it's only in such circumstances that it's foreseeable that that is compliant with Article 7 in relation to the scope of the penalty. My understanding has got absolutely nothing to do with whether or not the changes of execution or enforcement are foreseeable.
Yeah. If I may say so, I think my lord is right, because one knows that in the scope of Article 7, we have cases like SW in the United Kingdom about the way in which marital rape became an offence. And there it was regarded as not in violation of Article 7 because it was reasonably foreseeable that the law might develop in that way. And I think this section of the judgment is looking to see whether, in effect, Spain, this is Spain, isn't it?
Yes.
Had a defence that, although there had been a change in the definition of the penalty, could it be said that there was always scope for the penalty to be changed in law?
Yes, you mean whether there was a perceptible line of case law development?
So as my lord says, that doesn't seem to have anything to do with foreseeability in the sense you seem to be using the term. Well,
my lord, obviously, I as my lord observed, I did raise it in relation to Article 5, but I did, basing myself on that cross-heading and the question of foreseeability, I did raise it.
In Morgan, Article 5 came in as a sort of byblow. No one was really arguing it at all in relation to foreseeability. But all the same, it arose. And
Well,
But I don't understand your argument in relation to Article 5, in relation to foreseeability.
well, my Lord, I think I'm going to have to come back to that at a later stage because I'm supposed to be on Article 7. I'm sorry about that. If my answers are inadequate too, I apologise. Then, just as to those two cases, the re-MA case.
Can I just raise one other matter arising out of Del Rio Prado, but by all means do it in reply if you would rather. I realise you're burning into your reply.
Well, I'm just worried about...
Is there a point of distinction from this case implicit in the last sentence of paragraph 102, where the Strasbourg court, I think, came to a clear view that the inclusion of the remission provisions as part of the sentence was a matter of substantive Spanish law, whereas here, I think it could be said that it's not so much included as a matter of law, the relevant law all being set out in the 2000 Act, but as a matter of ministerial policy sort of loosely grafted onto the substantive law.
Well, my Lord,
I'm happy for you to do it now or in your report, but it does seem to be a point that needs to be addressed.
My Lord and my Lady, firstly, obviously, our first point is it is the case that the Smith rationale applies to those sentenced after 2000, and you have my submissions that as a matter of law they are entitled to a review. But secondly, insofar as I have relied on legitimate expectation and under the policy, I do respectfully submit that the removal in this particular situation also gives rise to arbitrariness and unjust retrospectivity. But I have to accept it's not a change in, as it were, black letter law or statute law. It's a change
We seem to be back on Article 5. When you say removal here gives rise to arbitrariness and lack of foreseeability, are we back in the Article 5 terrain?
Well, my Lord, both. I have argued it in relation to Article 7 too, but that's a submission. In relation to the case of re-MA, can I just make this point, that in the judgment of the court at paragraph 29, the court summarised the test as to whether the measure, quote, alters the scope of the penalty provided for on the date of which the offence in issue was originally committed, and they contrasted that with a mere hardening of the situation. And they talked at paragraph 35 on the fact that the changes, quote, do not lead to an increase in the intrinsic seriousness of the penalty. But we say that in our case, the removal of an intrinsic element of the sentence, namely the reducibility of the minimum term, does lead to an increase in the intrinsic seriousness of the penalty that was imposed from, as it were, reducible to an irreducible minimum term. And it's true that applying the test that they formulated paragraph 41 about whether it extends the maximum duration of the determinate sentence, we do not pass that test, but it does change the nature of the minimum term from a reducible minimum term to an irreducible one. And then, my Lords, the only other matters I should deal with is in relation to the JR case, JR 123. And can I just make this short submission? Having regard to paragraph 49 of In Re JR, this is not about a rehabilitation regime, but about a right to have the sentence reconsidered or to have one sentence reviewed. It's not so much about social policy, which was the formulation in relation to the rehabilitation policy. It's as giving effect to the rationale of a sentence. And obviously this is not about Article 8 rights, but about potential arbitrariness in the redefinition of a sentence. Moreover, as the court recognised in Re-JR at paragraph 57, I quote, avoidance of arbitrariness and inconsistency is a factor of significant weight in the present context. And we say that it is arbitrary to have excluded by reference to the date of sentence when the sentence is premised on liability from the date of commission. those, and my lords, in relation, can I just invite the court also to have regard to the annex to our case at pages 62 to 74, which sets out the whole history, showing that the judicialisation by another, i.e., treating the judge's views as determinative, had actually started earlier than the 2000 Act. And in the end, we say it was arbitrary to remove the possibility of a review and the prospects of a successful review, because the review implicit in the concept of detention during pleasure was an essential element of the rationale. My lord, those are my submissions.
Yes, thank you. So I think that's 18 minutes of your reply, just so you know.
Yes, thank you.
You're finished there. I don't think there are further questions.
Right.
Thank you very much, Mr. Fitzgerald.
Lords, my lady, can I start by addressing my learned friend's submissions on policy and the legislative background? 4 points, if I may. Firstly, any claim to identify the inherent or defining features of DHMP, or indeed any other sentence, must both respect and keep pace with Parliament's express provision as to what the features and requirements of that sentence actually are. We submit that is especially important in the DHMP context, because until the 2022 Act, with which we're concerned, the operation of a sentence of DHMP was in practice part legislation and part policy. And therefore, many of the leading authorities on DHMP were grappling with the legality of the Secretary of State's policy when considered against the backdrop of the then legislation. And the essential question, in cases such as Venables and Smith, was therefore, given the terms of the legislation as enacted by Parliament, is the Secretary of State's policy in conformity with that legislation, including any aspects of the sentence which may be properly implied into those terms? What they were necessarily not doing, we respectfully submit, for very obvious constitutional reasons, was purporting to limit what Parliament itself might do with respect to this sentence in the future, and specifically for present purposes, what Parliament might do as to the availability and scope of any minimum term review. It is, we submit, a legal non sequitur to argue for an inherent or implied requirement of this or any other sentence if it is contrary to the express words of primary legislation as enacted by Parliament. There could in principle, we submit, notwithstanding the powerful statements of Lord Bingham, there could in principle be no objection to Parliament's placing any minimum term review on a statutory footing and then determining to whom that review should be available. That is all critical, we submit, because the height of the appellant's submission now is that Parliament's enactment of Section 27A is inconsistent with the underlying rationale of the sentence, and we submit that is to put the cart before the horse. The rationale of the sentence is to be determined in the first instance by reference to Parliament's intentions as revealed in the express terms of the primary legislation. And we note too that one specific point advanced yesterday with respect to the language of at pleasure, we submit is legally impossible to contend that by using that language, Parliament has implied that in all cases there should be an ongoing duty of review in circumstances where Parliament has expressly prescribed the circumstances where there will and there won't be a review. Secondly, looking at the legislative arrangements now, before turning to the post-Section 82A, pre-Section 28 or Section 27A period, looking at the arrangements now, the arrangements under the 2022 Act are, of course, the latest in a line of legislative changes to the sentence that date back to its introduction as an alternative to the death penalty for children in 1908. It's been amended by 10 further statutes. The effect of these particular amendments, though, under the 22 Act is we respectfully submit significant in two respects. And together they perhaps mark the culmination of that history. Because, firstly, for the first time in both substance and form, the whole process of determining how long an offender should serve in custody, when they should be released, is in the hands of judicial bodies and not the executive. That's from the sentencing judge determining minimum term through, if appropriate, and in some circumstances to the High Court ordering a reduction of that minimum term, and then, of course, the parole board's final decision on release post-minimum term. The decision maker in substance and form is a judge or judicial body. Secondly, the entire process, including the minimum term review, is now on a statutory footing. And we respectfully submit it's not therefore an overstatement to suggest that these amendments mark the end of a process which, in very general terms, has seen the sentence of DHMP move from where essentially all aspects of the sentence, the term of detention, timing of release, were in the hands of the executive and operated according to policy, to one where the process is now statutorily founded and detention and release is in the hands of judicial bodies. And therefore, while in Smith, Lord Bingham criticised the DHMP legislation as a reactive piecemeal and particular, there is a proper basis now, we would respectfully submit, to characterise this legislation as deliberate and comprehensive, and with a very great advantage that the sentence, including any review process, is founded now exclusively on primary legislation. Thirdly, notwithstanding that it is deliberate and comprehensive, the legislation, we also have to recognise that the sentence itself is something of an anomaly, and it has two unique features. Firstly, the availability of the sentence is defined by the age of the offender when the offence was committed, rather than at the date of conviction. The ordinary approach, of course, is defined by the date of conviction. We've given the references in our case to the Sentencing Code, which is the current statute, the Sentencing Act 2020. If the court were to review, I don't think we need to go there, but if the court were to review Part 10, I can give the references, the court will see that the custodial sentences, which is Part 10, is divided into Chapters 1, 2, 3, and 4. Chapters 2, offenders aged under 18, and those are the sentences available where the individual is under 18 at the date of conviction. And for present purposes, that includes the possibility of a discretionary life sentence, which is not the ordinary life sentence, but detention for life for those aged those aged under 18. Chapter 3 concerns those aged 18 to 20 at the date of conviction, and there the discretionary life sentence is custody for life, page 828, and then at Chapter 4, those aged 21 and over, imprisonment for life. That's the structure, offence, dates, the sentence available defined by the date of conviction. The exception, of course, is detention at His Majesty's pleasure, section 258, by reference to the date of the commission of the offence. Secondly, alongside that aspect, unique as it seems to us with respect to DHMP, is, of course, the opportunity...
I'm so sorry.
I'm so sorry.
You said, see section 258, I think you said.
259, I'm
25, yes, I was just looking at it. I think you're setting out what you've got at paragraph 9 of your...
Paragraph 9 of the case, that's right. And I can give the page references. Chapter 2 is 814, DHMP, section 259. Chapter 3, 828. Chapter 4, page 835. Detention for life, just looking at the life sentences, detention for life, custody for life, and then imprisonment for life, the exception being DHMP. The second unique aspect, of course, is that there is the opportunity for a review, in some circumstances now, of the length of the minimum term. I'm going to return in a moment, of course, to the implications that we submit that has, the product of those two features together for Article 14. But just keeping an eye at the moment on the history and background, all of that we respectfully submit demonstrates that we are a number of very significant removes from Smith. In Smith, the House of Lords were considering the Secretary of State's policy against the legislation then in force. That was the Children and Young Persons Act 1933, section 53, which we have at page 781. Under the terms of that statute, the individual was liable to be detained in such place and under such circumstances as the Secretary of State may direct. So the tariff was fixed by the Executive, having obtained first the advice of the Trial Judge and the Lord Chief Justice. See Smith, paragraph 2, page 1250. And the policy that was in issue in Smith was, of course, a blanket policy, effectively, of the Secretary of State, which would see the tariff refixed for those already having been sentenced pre-30th of November 2000, and then subject to no further review. neither legislation before the court or the legislation that was then waiting in the wings made any express reference to the review or its existence or otherwise. Now, of course, the legislation is, as we've seen, Section 259 of the Sentencing Act, and before that, Section 90 of the Powers of Criminal Court Sentencing Act, and the statutory provisions under Section 27A deliberately do draw a distinction, consistent, I'll submit in a moment, with what we say is the underlying rationale of the sentence, as between those who can and cannot obtain a review of that minimum term. The issue that has arisen, of course, is the period between the decision in Smith and the 2022 Act. And we've set out in our case, Section E, starting at page 85, paragraph 44.
Paragraph?
44, sorry, my lady. Paragraph 44, the legislative and policy background, defined there by reference to three essential periods: the pre-November 2000 legislative era described and considered in Smith, then the 30th of November 2000 through to 27th of June 2022, interim period, and then, of course, since June 22, which is the legislative provisions that I've just described. In terms of the second era, we start that at paragraph 99. I'm not going to rehearse what we've set out there, but that I know is a point of some issue going to my learned friend's submissions on legitimate expectation. Just would draw these additional observations as to that period. Firstly, as at the date of the hearing in Smith, the Secretary of State's position was that there was no minimum term or tariff review available after the 30th of November 2000. We see that in Smith, page 1248. The House of Lords, of course, accepted that was the Secretary of State's position, but expressly declined to grapple with that analysis. And the points were that although there was no express reference to a tariff review and or their removal, this was, of course, now a judge setting the tariff, and it might be said, therefore, that, as it was yesterday, Parliament has occupied the field. We have to recognise, though, that thereafter, following Smith, a policy of review was nevertheless adopted by the Secretary of State. You have that in Mr. Webster's statement, paragraph 6 to 7 on page 428. And now, of course, we have PSO 4700, which indicates at paragraph 7.1 that we went to earlier this morning, that the Secretary of State has recognised, following Smith, required to keep under review the tariff of HMP detainees sentenced before 30th of November. The Secretary of State has since decided to extend those arrangements to cover all HMP detainees. Thirdly, there is, as the Court of Appeal identified, an issue as to the basis upon which that process was being conducted consistently with the terms of Section 82A. And it might be helpful just to turn, if we may, to the Court of Appeal decision, paragraphs 40 and 43. Which we have, page 130, and then 43 is page 131. And I think 43 recognise as follows: the precise legal basis upon which the Secretary of State continued to consider application to review a minimum term fixed by the sentencing judge was not fully considered by the courts. Unlikely that the power derived from the statutory provisions governing sentences. In Smith, though, Lord Bingham had said at paragraph 13, a reduction in the sentence is a well-recognised exercise of executive clemency, and there was reference to in Cunliffe that the Court of Appeal looked at, describing the position as the Secretary of State does retain a general power of executive clemency. And the Court continued, the exercise of a prerogative power, this is the Court of Appeal, to review the minimum term in the light of events after the minimum term was fixed would not necessarily be inconsistent with or impliedly removed by the statutory framework created by Section 82A and now the Sentencing Act. But in any event, Parliament has now provided, of course, that there is no right for an offender, save as under Section 27A1. My Lords and my Lady, I can't improve on the Court of Appeal's observations as to the legal authority and power as to which, or under which, the Secretary of State was acting during that period. We do know, though, returning to Mr. Webster's statement, paragraph 17, page 431, that there was thereafter a change of policy in February 21, and that, as my Lady Simler pointed out this morning, that of course demonstrates that any legitimate expectation that I'll address in due course is inevitably circumscribed by the Secretary of State's ability to change whatever policy was in place. That wasn't, of course, the subject of any challenge.
Can you give us a page reference for that policy?
I'm so sorry, for...
The February 2021 policy.
Yes, page 586 I have, but that, I just want to check that's not merely Webster, but I think it's an exhibit. It's behind 25.
Yes, it is.
It's the, yes, that's his 7th exhibit. Then, of course, we have the statutory arrangements. We've looked at 27A already, but could I just ask the Court to turn, please, to 27B, because there we have Parliament's approach to the issue of, in inverted commas, retrospectivity. Page 865, tab 44, because there was consideration given as to how these matters should be brought into force. So if you see at page 865, 27B3, and 27B, subsection 3, a pre-commencement application. So Parliament's assessment was that there should be provision made for those who had already been sentenced under the former arrangements or were serving a sentence already, if they had already made an application having served at least half of the minimum term. That was to be treated as a pre-commencement application and therefore to be treated under 27A4 as if it had been made under that section. So it isn't right, we respectfully submit, to suggest that no consideration was given to that issue. So, my Lords, my Lady, I was going to turn then to Article 14 on the basis that that's where my learned friend started, and the substance of the Secretary of State's response there. 4 submissions at the outset. Firstly, we respectfully submit that the issue under Article 14 is or ought to be a narrow one, which is the product of the 2 features I've already described, i.e. that the sentence must be imposed whenever the individual is being sentenced, if they in fact committed the offence age under 18, and secondly, the availability of a review. Because the product of those 2 features we respectfully submit, and this is in our case, paragraphs 9, I think. I may have to give a better reference. Paragraphs 9 to 10. The product of those 2 features is that there are obviously a spectrum of offenders, some for whom all of the features, protective features surrounding the sentencing of children are very obviously and directly engaged. For example, someone who commits a murder age 10 being sentenced as young as 11. And at the other end, there are those for whom, of course, those aspects of the protective features surrounding the sentence of children are very obviously not engaged. Some of them are not engaged. See, for example, Stephen Lawrence's killers, Dobson and Norris, sentenced to DHMP 19 years after the offence.
I think you're saying that that's reflective, actually, of the anomalous nature of DHMP as regards how, when you impose the sentence and assess the sentence.
That's right.
Because it's out of line with the other aspects of sentencing policy, where it's done whenever the offence was committed at the date of the sentencing exercise.
Precisely, my Lord. Yes, it's normally fixed at the date of conviction, and I think it is the product of the 2. It's the fact that it can be imposed on a range of offenders, some of whom are still very young when they're before the court, others of whom may be very old by the time that they're before the court. And then the question is, well, alongside that aspect, the review. What's the purpose of the underlying rationale of a review when you're dealing with middle-aged offenders, or rather those who are now before the court in middle age? And what we respectfully submit from that aspect of this sentence is that there could be no principled objection under Article 14, by reference to age, to Parliament's legislating to remove any right to apply for a minimum term in the case of offenders who are sentenced as older adults. The primary thrust of the appellant's complaint, before we get to retrospectivity, etc., is that setting the line at 18 didn't take full account of maturation, which I accept, of course, that I need to deal with and will do in due course. But the real issue, therefore, under Article 14 is a narrow one. It's not whether Parliament acted incompatibly with the Convention by setting a line at all. The issue is, was it right to set the bright line at 18 as opposed to, for example, 26? And I'm going to deal with that, but that is the narrow issue we're dealing with. And of course, here, we respectfully submit that the court can properly and ought properly to pay regard to the fact that an amendment at 26 was considered, that I'll return to. But secondly, that also demonstrates, we submit, is that rather than legislating in a manner that is contrary to the fundamental rationale, as my learned friend would describe it, of a sentence of DHMP, the broad thrust of the amendments is entirely consistent. The fundamental rationale identified by my learned friend is that the minimum term is capable of review on the basis, it said, that in due course a more reliable judgment may be made as to what punishment the offender deserves. Period of detention will best promote rehabilitation, having regard to their growing into maturity. All of those statements, of course, they attach to an offender being sentenced age 10, 11, under 18, or as a child. They have no relevance, we respectfully submit, to a person being sentenced age 45, for whom none of those considerations can apply at all. Indeed, we respectfully submit there is no rationale whatsoever in the case of someone aged 50 having a review on the basis that there's only been a provisional assessment then as to their culpability and what's required in terms of sentencing them. The second broad set of issues...
Sorry, and just on that, I think it's in that context that you need to address the point about people go on maturing up to 25, because you picked someone aged 45.
I agree. I've obviously, my Lord, taken the extreme to demonstrate that we're consistent with the rationale. I'm going to come to that precise point on ongoing maturation. I'm not seeking to avoid it by just picking the extreme, but trying to narrow the issue. Secondly, importantly, we respectfully submit, what Parliament did and didn't do, Parliament, through Section 27, made no change to any other aspect of the sentencing exercise conducted by the trial judge for those who commit murder as a child under 18. All of the ordinary approaches, sentencing approaches to those as who commit offences as children are retained and respected, notwithstanding Section 27A, and the proper approach of the difference between sentencing those who commit offences in children as children rather than as adults, all respected and maintained, as we respectfully submit, happen under Section 27A. And that, we submit, was the primary of the divisional court's decision, which was to suggest that 27A ran counter to well-recognised sentencing principles. We submit that it plainly didn't. Thirdly, the rationale for locating the bright line by reference to the point of sentence. We submit there can be no principled objection to fixing the availability or otherwise of the right to apply for a minimum term review by reference to the offender's age at sentence. It is neither arbitrary nor capricious. In fact, it is the only date rationally connected to the issue in hand. The issue in hand is whether it can be properly said that the minimum term prescribed at the date of sentence ought subsequently to be capable of being reviewed. If you're going to discriminate between offenders as to who does and does not have the opportunity to apply for a reduction in that minimum term on the grounds of age, the relevant date is the date of sentence. It's the date, we submit, which most obviously separates out, on the one hand, the Thompson and Venables cases, and then Dobson and Norris on the other. Fourthly, the justification for that bright line falls to be considered, we submit, in a context where the criminal law and practice affords no other opportunity for a minimum term review of any other person who commits a serious offence, either as a child or indeed as an adult. That is directly relevant, we submit, to the question of justification under Article 14, because it cannot be said that the default position is that a review is ordinarily available. Quite the opposite. The default position is that there is no minimum term review ever available, save in this particular context. We'll come back to JR 123, paragraph 50, but I think there is a point as to the absence of consensus here as to the importance or significance of any right, as it's put, to a review of a minimum term. It simply doesn't exist elsewhere in domestic law, nor is it recognised as a matter of convention law. Turning then to Article 14, as the Court recognises already, the only issue is justification. The one point, though, I do need to address is, of course, margin. We submit that on this issue, perhaps the only issue on which the Divisional Court and Court of Appeal agreed, they were both correct to recognise that a wide margin of appreciation applies here. Margin, of course, varies according to circumstances, subject matter and background. See SC paragraph 37.4, page 1198, citing Carson. But we submit a wide margin is appropriate here, given as correctly identified by the Court of Appeal the following features at least. Firstly, the discrimination is not on any so-called suspect ground, but on the grounds of age.
Can you just give us the paragraph?
Court of Appeal.
Court of Appeal, yeah.
Yes. I'm sorry, no, let me do that. I may have to come back to that.
Yes, all right.
I remember that it's weaved in through various passages. So, but
this is an exercise that this court should be carrying out.
Yes,
rather than finding a flaw in the exercise.
I recognise that. I think we're Schvidler, paragraph 144, on full assessment review here. Yes, but you have it at paragraphs 123 to 128.
Thank you.
Especially 123 and 128, pages 162 to 163. So firstly, discrimination not on any so-called suspect grounds, but on the grounds of age. Secondly, and I know I need to address this, but in the context of what we would properly characterise as a penal policy context. And thirdly, of course, the issue here concerns the compatibility of primary legislation. And could I just turn as well, I think now is the sensible time to do it, to JR 123. Grateful to the Court for drawing that to our attention. Apologies if we should have identified it sooner, but just turning to paragraph 48 and the matters that are set out there under margin. No, I need to make these good, but just to show where we would say we fall within the matters identified. Does the Court have it? I can't give a page reference.
It came through separately. I'm just looking at my
I
colleague.
think it's been uploaded.
I'm struggling to get back to it. Here we go.
It's 1278 internal pagination, if that helps at all.
In fact, not when you're doing it electronically, but it's page 23 electronically.
Thank you. So paragraph 48. Wide margin of appreciation for the legislature in the present context, a number of relevant factors. Obviously not all of these apply, but the ones that we would respectfully submit do. First, in that context, in JR 123, recognition that there, the interests of promoting rehabilitation offenders are difficult and sensitive questions. This is the middle of paragraph 49. They call for judgments to be made about social policy, including questions of moral and political judgment, very much the province of the legislature, and in relation to which the margin of appreciation is wide. And we do respectfully submit that we are here considering matters of policy, going beyond the individual factual circumstances of any particular person's case. And they are judgments that are to be made, essentially balancing on the one hand the interests of the families of victims and on the other those of offenders. Secondly,
I wonder whether it's slightly wider than that, because it's the administration of justice.
Yes.
Generally.
It's a penal policy case.
Yeah.
Yes.
So it's not just concentrating on the offender and the victim, but it's also looking wider than that at the impact on society as a whole.
My Lord, I entirely agree, and I'm going to look in a moment at Clifton then Stott, because I think the distinction is drawn out by comparison of those two cases, both in a prisoner context, as it were, so quite close to home, And the submission is going to be that this is a proper policy context case rather than an individual offender, and therefore we are into questions as administration of justice, the criminal justice system, etc.
Yeah, I think it's the same point, but criminal law has a signalling function for society as a whole.
Yes.
It is expressive of social policy that criminal law is framed in a particular way.
Absolutely, my Lord. And the interests of victims is an aspect of that, is a policy aspect of that. And decisions taken as to whether they should be involved, to what extent they should be involved in the process of criminal justice is also a very significant policy matter.
Yeah.
Paragraph 50, the point I've already, I think, made on the absence of a consensus.
Well, I was wondering about that. The consensus, there's no consensus, certainly, in the United Kingdom, and there are no Strasbourg authorities. But what Strasbourg looks at is there are other jurisdictions within the Council of Europe that do apply
yes.
something along the same lines. And I'm sure that you haven't had the time to carry out that survey.
No, I haven't. We haven't carried that out, but there's certainly no evidence to suggest that there is. Yeah. That there is an approach generally that sees tariff or minimum term reviews in Europe somewhere, and certainly I would respectfully submit if there were such a consensus and they were widely available, that we would have seen them bubble up through the convention case law before Strasbourg. Thirdly is paragraph 54, over onto the next page. Usually be a wide margin if the state is required to strike a balance between competing private and public interests or convention rights. And we do submit that we're in that territory too. Fourthly, paragraph 55, the desirability of maintaining, quote, the coherence of the administrative and legal practices of the domestic system, and essentially asking the question as to the extent to which there would be an imposition of additional burdens on the state, and I think there is something of that here, but I don't think it's quite as significant here as it was in JR 123. Fifthly, paragraph 58, careful policy consideration of how the regime should be structured. We'll see that in a moment, given the white paper, and then, of course, Parliament's own consideration of the precise issue here. Sixthly, paragraph 60, the margin of appreciation will tend to be narrowed where a particular important facet of an individual's existence or identity is at stake, and we submit not in that territory, age not being a suspect ground. So, turning then to the detail on age, and just to do this briefly, because in the appellant's case there's a reference to there being the need for a higher intensity of review where legislative changes might have an impact on the best interests of children. That is taken, I think, from SC, paragraph 158, page 1232, but we submit that that cannot be applied in this context, because the premise of the distinction in issue here is that the offender is in law an adult. We are not dealing with the sentencing of children, or rather the discrimination, in inverted commas, respects the distinction between, and indeed it rather applies it, between children on the one hand and adults on the other. So we are, instead, we submit, in the territory of age as a ground of difference in treatment, which is not a suspect ground. If you need authority for that, SC, page 117, that's the start of the decision, paragraph 114, page 1218, the counterpart of the strict approach.
What paragraph number, sorry?
Sorry, 114, paragraph 114, page 1218. This is after Lord Reid has set out in some detail various suspect grounds from paragraph 100 onwards, birth status, nationality, sexual orientation, race, ethnic origin, etc. But then paragraph 114, the counterpart of the strict approach taken, other things being equal to differences in treatment on the grounds discussed above, is less strict scrutiny, other things being equal, of differences in treatment on other grounds, such as age.
Does the statutory welfare principle no longer apply when the offender achieves the age of 18?
No, my lord. Once they're before the court as an adult, then no.
And has that been considered in Smith?
My Lord, it was considered in Smith, and the view taken there, I have to accept, was that nonetheless, it wasn't sufficient to save the Secretary of State's position on that ground. But my respectful submission is that Section 44, on its terms, makes clear that it applies to children only and doesn't apply to adults. I have to accept that it's referred to in Smith, yes. Turning then to the penal policy point, we do submit that the case is correctly characterised as a prison penal policy case. The distinction we identify is through essentially a compare and contrast exercise of Clift and Stott. We have Clift, page 1604, tab 69. 1604, it starts at 1582, Clift, paragraph 73. Sorry. Tab 69.
Page 69 or paragraph 73?
Sorry, I'm going too quickly for myself. Tab 69, page 1582 is where the judgment begins. I hope the court has that. And then 1584, paragraph 3, sets out the background to the issue. And the key features of the background there that we submit are relevant to this question of margin and how the ECHR approached the question of margin in Clift. The key features there, paragraph 3, the applicant alleged under Article 5, together with 14, that his continuing imprisonment following the recommendation of the Parole Board on the 25th of March 2002 that he be released on licence violated his rights under the Convention on account of the difference in treatment between prisoners serving fixed-term sentences of less than 15 years or discretionary life sentences, where in both cases a recommendation of the Parole Board resulted in release, and those serving fixed terms of 15 years or more, where in addition to the recommendation of the Parole Board, the approval of the Secretary of State was required. So the key point in Clift was that he remained detained after the Parole Board had concluded that he was no longer a risk to the public. And the reason for that was because the approval of the Secretary of State was required. So in that context, paragraph 73 on page 1604, in that context, and I should perhaps draw attention to paragraph 72, the government had called for a wide margin of appreciation, emphasising it didn't concern any suspect grounds such as sex or race. Paragraph 73, however, the court can read the court's assessment. The key point to which we would draw attention for these purposes is the final sentence, page 1604. While in principle a similarly wide margin of appreciation applies in questions of prisoner and penal policy, the court must nevertheless exercise close scrutiny, whereas a complaint that domestic measures have resulted in detention which was arbitrary or unlawful. It goes on over the page to conclude that that is indeed what had occurred and what was occurring in Clift because of the Parole Board's decision. If you go down to paragraph 77 on page 1605, in the present case, the government have failed to demonstrate the approval of the Secretary of State would address concerns regarding the perceived high risk posed by certain prisoners on release. By the time the Secretary of State rejected the Parole Board's recommendation the applicant be released, life prisoners had been brought within the definitive jurisdiction of the Parole Board. So therefore there was a differential treatment that had become, quote, an indefensible anomaly, as the assessment of the risk presented by an individual prisoner in the application of publicly promulgated criteria was a task which, at the relevant time, recognised to have no political content, and one to which the Secretary of State could not and did not claim to bring any superior expertise. So concluded there, discrimination. We contrast that, though, with Stott, which is behind tab 78, so starts on page 1818. This concerns early release provisions, paragraph 5 to 8. but just focusing on margin, page 1842. The Court's assessment begins there, paragraph 94. Considered paragraph 101, this is page 1844, the decision in Clift that we've just looked at. But it goes on, paragraph 102. By contrast, the present case concerns the point in the applicant's sentence at which he'll become eligible to seek early release. This is a question of entirely different nature, plainly not covered by the Court's comments on risk in Clift, since the Court there expressly limited its conclusions to, quote, the assessment of the risk posed by a prisoner eligible for early release. Whereas the question whether a person eligible for early release posed a risk was, under the applicable framework in England, a purely factual one, on which the length of the initial sentence could have no bearing. The question whether and when a person ought to be eligible for early release at all is not. Its answer may legitimately depend on policy as well as factual considerations. And we submit that that's the touchstone of the issue. Page 1844, paragraph 102. The question is whether the issue is whether the answer may legitimately depend on policy as well as factual considerations. And we submit here that this is plainly a policy case. The issue is not simply concerned with the arbitrariness of an individual's detention or the facts of their detention, but rather the policy question as to the circumstances in which there should be the availability to seek a reduction in minimum term. And that's the distinction we would draw here as between the stock line of penal policy cases and the Clift line. So that's margin. Turning then to objective justification, given that we're dealing with primary legislation, the first set of issues under this head concerns what the Court is properly to make of the parliamentary materials here, in particular the White Paper and the discussion in Hansard, and of course then the internal Home Office documents. We would identify two specific questions: what material can be looked at and how is it to be approached? And we submit that the answer to those questions is in SC, which we have behind tab 56, page 1170, but the relevant passage begins at 1233. Just ask the Court to turn to that, please.
Right, paragraph?
165.
Yes, thank you. Actually, that starts on 1234, I think.
Sorry, yes, it's introduced under the heading Use of Parliamentary Materials on page 1233.
Yes.
Begins at 163. But the points that I wanted to draw attention to are within paragraphs 165 and 166. First, the general warning of Lord Reid, paragraph 165, about the constitutional impropriety of courts exercising a supervisory jurisdiction over Parliament. No part of the functions of the courts under our constitution to exercise that jurisdiction over internal procedures. Secondly, paragraph 166, another constitutional fundamental which needs to be borne in mind is the government is separate from Parliament, notwithstanding the many connections between the two institutions. That taken from Wilson. And then two further points, paragraphs 167 and 168, to which we draw attention. They're still on page 1234. Firstly, the will of Parliament finds expression solely in the legislation which it enacts. Parliament doesn't give reasons, it simply votes on a motion to approve proposed text. And then 168. Secondly, decisions taken by Parliament are not necessarily capable of being rationalised in any event. It is a debating chamber. And we see the further consideration of those issues. And 171, far more far-reaching consequences that the courts have to be careful not to undermine Parliament's performance of their functions by requiring it or encouraging it to conform to a judicial model of rationality. And 172, the reference to the intention of Parliament essentially being a legal construct. So that answers the one aspect, of course, of the question. What can be looked at is, of course, the statute, but with the important point being that the will of Parliament finds expression solely in the legislation which it enacts. Perhaps of more significance here, Lord Reid turns next to additional background material, paragraph 174 on page 1236. So this is, of course, in the context of proportionality. Court must decide whether the means used by the legislation to achieve its policy was appropriate and not disproportionate. For those purposes, reference could be made to parliamentary debates and other parliamentary material. And then Lord Nichols, this is from Wilson, paragraph 63. Sometimes the court may need additional background information tending to show, for instance, the likely practical impact of the statutory measure and why the course adopted by the legislature is or is not appropriate. And then through paragraph 64, the additional background material may be found in published documents, such as a government white paper. If relevant information is provided by a minister or indeed other member of either house during the course of debate, the courts must also be able to take this into account. So, my lords, from that, what we submit, that is the proper lens through which documents such as the white paper have to be considered. It is one where the court is essentially seeking to identify the mischief at which the legislation is aimed, which might shed light on the rationale underlying the subsequent legislation. It's an approach we submit which carries with it an assumption of a degree of circumspection. It is about identifying mischief. It's not about looking to see if Parliament has rationalised or sufficiently argued its case. That would, of course, submit the prohibition on requiring Parliament to conform to a judicial model of rationality. And then thirdly, after that background material, Lord Reid goes on to consider Hansard itself. We have the observations on that from paragraph 175 onwards, but the key passages we submit at paragraphs 180 through to 185, and we would highlight there, in particular, paragraph 180, page 1238. Firstly, the degree of respect will depend on the circumstances, whether Parliament can be taken to have made its own judgment of the issues. Secondly, noting at paragraph 181 that the European Court takes account of whether the legislature has considered the matters relevant to a measure's compatibility with the Convention, although, of course, that's by no means determinative of the issue. 182, though, if it can be inferred that Parliament formed a judgment that the legislation was appropriate, notwithstanding the potential impact on interests protected by Convention rights, and that may be a relevant factor in the Court's assessment because of the respect the Court will accord the view of the legislature, subject to two caveats, paragraph 183 on page 1239. First, the Court should go no further than ascertaining, quote, whether matters relevant to compatibility were raised during the legislative process, if they're to avoid assessing the adequacy or cogency of Parliament's consideration of them. And 184, second caveat, the absence or poverty of debate is not to be treated as reason supporting a finding of compatibility. And noting paragraph 185, in practice, in a case of the present kind, they generally raise issues which are at the forefront of debate as they were in the present case. But the focus of the exercise is, of course, as I say, 183, going no further than ascertaining whether matters relevant to compatibility were raised during the legislative process. So with that legal framework in mind, we would turn then to the materials here. Firstly, the white paper, page 555, behind tab 25. These are the relevant passages, paragraphs 328 through to 331.
I'm so sorry, can you read the page number again?
Yes, 555.
Thank you.
The section begins the page before 554, but the relevant passages are paragraphs 328 to 331. We submit that the mischief identified at the outset is that the existence of the review procedure can be extremely distressing for the families of victims. Families are contacted every time an offender applies for a review and are given the opportunity to provide a new victim personal statement, a process which in many cases causes them to relive the second of the crime and feel as though they have to advocate again for justice for their loved one. The review process there described as characterised as extremely distressing. We submit that can't be in doubt. And the second aspect, going to the justification of age, setting the line, the bright line is 18, adults do not go through the same accelerated development and maturation that children do. We submit that those are the 2 points that can permissibly be taken from the white paper. That's not an answer to the ultimate question, but that's what we say can be derived from them. As to the appellant's criticisms of the white paper, to deal with those now, paragraph 329 we do not submit that there can be any criticism of this paragraph as suggesting that the Parliament had misunderstood or been misinformed as to the policy at the time. It is correct that when the white paper was published, the policy did not conform with paragraph 329. That's explained by Mr. Webster, page 430, paragraph 14. But actually, you see further on in his statement, as we've looked at already, there was an amendment to the policy. That was on the 18th of February 2021. And so by the time Parliament debated section 27A on the 10th of June 2021, it was correct. And indeed, if the point were taken against me on the actual discussion in Parliament, Parliament proceeded on the basis that there was, that the position was that there was, this would be the removal of a review that existed at the time.
Sorry, can you just say that again?
Yes, sorry.
So when was the parliamentary debate?
On the 10th of June 21. And the amendment to the policy was on the 18th of February 21. So by the time Parliament debated it, there's coherence between the white paper and the actual policy of the Secretary of State.
But was the amendment to the policy something equally visible to Parliament as would have been the white paper?
I don't think I can't say it would have had the same level of visibility, no.
I mean, how would it in practice have been accessed by a reasonably diligent MP?
Well, it would have been, I'll take instructions on that, but it would undoubtedly have been promulgated publicly, so it would have been available if an MP wanted to check it, but the white paper conformed with the policy as it then stood by the time Parliament debated the issue.
What's the page number of the policy again?
It's page 586.
And is that a document put into the library, Parliament's library, or not? Does it declare on its face what happens to it?
It doesn't, my lord, but it's plainly no, my lord. It plainly is though a published document, and there's a reference to other aspects of what's described as the generic parole process policy framework, which is available on the internet.
And so this document is, that we have, is reissued 21st of July 2022. But you say that the on page 588.
Sorry, I'm looking at page 586,
right,
which is the revision to the existing policy, which is introduced by Mr. Webster, exhibited by him. And he describes it as a circular, so this is paragraph 17 on page 431. The Secretary of State implemented the revised policy and also amended the Ministry of Justice's generic parole process policy framework, that is the GPPF, on the 13th of May to reflect those changes, 13th of May 21, which is the document that we have behind tab 18 on pages 587, 588. I am concerned because I've worked from a hard copy that I've had throughout the proceedings, which has at the end of it reissued 13th of May 2021, which accords with paragraph 17. And so I'm slightly...
a different date.
And I'm concerned that when it came up in discussion yesterday, that somehow I think somebody has re-downloaded the document. But mine says reissued 13th of May 2021, but
well,
perhaps
in due course, can we be provided with a copy of that?
And paragraph 17, though, states in terms, the Secretary of State amended the MOJ's generic parole process policy framework on the 13th of May 2021, which does accord with the
And is that the reissue date on your version?
It is, 13th of May 2021. Yes, page 588.
Right.
And how do we get the date of the 18th of February 2021? What document is brought into existence on that date?
That is the revised policy. So it may help if you just look at paragraph 17 on page 431
Yes.
of the Webster statement. And does your Lordship see there, on the 18th of February, the Secretary of State implemented the revised policy
Yep.
as set out in the circular.
And AW17 is at
Is page 586.
I
That's
suppose
headed.
you might say it doesn't really matter whether Parliament had that drawn to its attention, but it simply, behind the scenes, put right a mistaken impression in the white paper as at the
Yes.
date of the publication of the white paper.
That's right.
Yeah.
Yes.
Yeah.
I'm only just seeking to...
I think that's your point, isn't it?
That's exactly my
There may
point.
have been a discrepancy before, but
There's no basis.
it's removed by the time the white paper is considered in Parliament, even if it were legitimate to have regard to these sorts of matters, and in paragraph 184 in
Exactly.
SC.
That's
You
exactly.
say, even if you did,
That's
Parliament
right.
has not been misled, it's understood
Precisely.
well.
So then, just returning briefly to the white paper, paragraph 329, whatever...
Sorry to take up time.
Of course.
I'm looking at page 586, which was exhibit AW1/7.
Yes.
Is this the document that you say you've got with a date on it?
No.
No.
That one has no date on my copy, and I don't think it has a date on the
No,
course.
it doesn't.
It's page 888 that has...
588.
That's, I'm so sorry, 588,
Yeah.
that has reissued in a 2022 date.
Yes.
And mine has 13th of May 2021 date.
Yep. Okay.
We'll sort that out.
Yes, of course.
We'll end up with a conformity between, I'm sure, between AW8 on page 588 and the statement.
Yes, right.
Paragraph 328, then, the criticism made, paragraph 329, is that, 328 and 329, that it's the continuing reviews that is the issue that's raised in the white paper. Respectfully submit that that isn't quite right. It's the existence of the review process, of the review procedure, paragraph 328, page 555, particularly the opportunity for continuing reviews after the halfway point. There is some reference in my learned friend's case, but I don't think we went there yesterday, to paragraph 330, but paragraph 330 is referring to those sentenced to DHMP as children, and therefore it isn't relevant to the circumstances of this appellant. My lords and my lady, just against that background, that is the limit of what we say can be drawn properly under SC from the white paper. The Home Office materials, my lords, we've put them in as background material, and I think, candidly, because we had to explain the white paper and we wanted to set out the policy background as well. But I respectfully submit that there must be real caution in, even if it might be said to assist me, in drawing anything from the internal materials within the Home Office and the discussions surrounding it. The key point is the public-facing document, CSC, which is, of course, the white paper, which is, and only then to a limited extent of identifying the mischief. We do, though, have Hansard that I just invite them...
And just to be clear on that, I mean, the underlying reason why we shouldn't be concerned with the Home Office materials is essentially because the relevant policy being tested here is the policy adopted by Parliament itself in legislating. So we're looking at Parliament's reasons for legislating. If Parliament didn't know anything about the internal Home Office debates, it's difficult to see what relevance that could have.
Absolutely.
In assessing the proportionality of the legislation.
Absolutely, and we didn't rely on them in the court below, in the Court of Appeal. They're there as background. Turning, though, to Hansard, we have the debate at page 658, tab 29. The question, of course, being whether Parliament can be taken to have made its own judgment on the issues which are relevant to the Court's assessment. SC paragraph 180, page 1238. And consistent with that, just to give the warning as much to myself as anyone else, paragraph 183 of SC, page 1239, courts should go no further than ascertaining whether matters relevant to compatibility were raised during the legislative process. No question of determining the cogency of Parliament's evaluation of that issue, etc. And of course, I think the court has seen the Speaker's letter, paragraphs 23 to 24.
Yes.
On Hansard, the points that I do think we can properly record in terms of the facts. Parliament, of course, expressly considered an amendment which would have raised the age at which 27A would apply from 18 to 26 and rejected it. That's page 661 is the proposed amendment. Parliament recognised the precise point in issue here, namely that one of the effects of section 27A was that those sentenced at age 18 would no longer be entitled to a review of their sentence. So not just a question of repeated reviews, but rather would no longer be entitled to a review of their sentence. Parliament recognised that the mischief or the intention was to spare families the trauma of having to revisit the events, the significance of which was recognised. Parliament recognised the concern that those who commit offences as children should be treated as children, page 661. Recognised the implications of court backlog on delays to sentencing causing a delay to sentence. Consider the implications that the amendment had for Lord Bingham's observations in Smith, page 662. Recognise the effect of a bright line cut-off at 18. Recognise that development continues beyond 18, page 662. And we respectfully submit that generally it is clear that the amendment was grappling with exactly the same issues that are relied on.
When you say Parliament recognised, this MP, Mr Cunningham, asserted all these things, and your real point is not so much the Parliament recognised it, but had it put on the table and must be assumed to have given due consideration to it and given it such weight as it thought fit.
Yes, and I
which might have been, actually, we don't recognise it, but that doesn't matter on your submission.
Yes, I suppose I was, rightly or wrongly, was seeking to ensure deference to Parliament by looking only at the end result.
Yes.
And the end result is 27A.
Looked at, and for their own reasons, which we don't, I think, get, so that the amendment is rejected, didn't accept.
Yes, exactly. Yeah, yeah.
But this fits, I think you say, with what Lord Reid said at paragraph 183 in SC about all you can do, compatibly with Article 9 of the Bill of Rights, is look to see that whether issues have been raised.
That's right.
And you say, well, they have been.
Exactly. And that's all I'm seeking to do, which is why I gave myself the warning. Yeah. Paragraph 183.
Yeah, the
temptation to do more
arguments. And I mean, as my Lord points out, these are arguments put forward by one MP.
Yes.
It's inherent in the nature in which Parliament does its business. You don't know what all the other MPs thought about it, and no one issues a declaration saying, well, this is what we make of it.
I entirely agree.
Yeah. I'm simply quibbling your use of the repeated use of the
recognised, yes. Well, I hope I've explained why I was using
yes, no,
it, but I accept it might have been misleading, yes. That's Parliament, and you have the submissions that we make on the significance of that. So, turning then to justification and therefore fair balance. We would synthesise the tests and the justifications as follows. The legitimate aim pursued is the protection of victims' families, and the means adopted to achieve that end are proportionate, and specifically, the selection of age 18 as the bright line cut-off is proportionate, given that adults, i.e. those aged 18 and over, do not go through the same accelerated development as children do. So firstly, on the legitimate aim of protecting victims' families, we respectfully submit that was, quite rightly, is an extremely powerful consideration for Parliament properly to take into account. Any minimum term review will engage the interests of the victim's family. In fact, we don't have it before the court, but there is statutory guidance issued under Section 33 of the Domestic Violence, Crime and Victims Act 2004 that refers to victim personal statements being used in tariff review hearings.
Can you give us that reference again? Section 33 of the...
Section 30, it's guidance issued under Section 33 of the Domestic Violence, Crime and Victims Act 2004, which at paragraph 7.9 refers to victim personal statements being used in parole hearings and tariff review hearings.
And we don't have either the act or the guidance.
I'm afraid we don't, no, my Lord, but we
Could
can
they
make that
supplied hereafter?
Of course,
Yeah.
of course.
Yes.
And that is properly reflected, we submit, in the approach of contacting families when an offender applies for a review and giving them the opportunity, and that's set out in Mr. Webster's statement, to give a new victim personal statement. Hardly needs to be said, we submit, that Parliament could recognise that such a process would potentially cause extreme distress for a family. In our submission, the Divisional Court wrongly minimised this point by reference to the, if you like, the objective relevance of the family's input to the review process. That's there, paragraph 56 on page 193. The niceties, though, of the legal relationship between their engagement in the process and the outcome of the review, it isn't an issue. What is being put in the balance is the subjective impact on victim families, and that was recognised by Parliament as a legitimate aim to be pursued, and on that basis. And although it's right, of course, to record that they have a proper role in the parole board process, it's not right to say that the minimum term review is any lesser than that process. Arguably, a matter going directly, which a minimum term review does, a review going directly to the punitive element of the sentence is likely subjectively to be a matter of very significant concern to the victim's family. So that's the legitimate aim. Then the means adopted to achieve that aim...
It did seem to me that one might say potentially that's of even greater concern than, than a parole board hearing where
you've served your
the
time.
Punitive element has been served. Families are often very directly concerned with the punitive element.
Yes, and once you're at parole board stage, there is a sense that the minimum term is served. Now it's a different question about risk. But the minimum term is going directly to the very matters that the victim's family are going to be most concerned by, arguably, which is the punitive element of the sentence that has already been imposed. And already been imposed having regard to their own statements that would have been before the court.
Yes.
So that legitimate aim, with that in mind, we submit the means adopted here to achieve that aim are proportionate, and the selection of 18 as the bright line cut-off is proportionate. To address my Lord's point earlier, obviously you need to take this head on. 3 points we would make here. Firstly, in terms of justification, Parliament's approach of setting the line at 18 enjoys, we submit, a very good head start, given that it has set the bright line at the most widely recognised date known under English law and in English society of the differential between a child and an adult. It also, the age of 18, has very significant implications under English criminal law and within the sentencing process. While, of course, the age at the date of offence is highly relevant, that isn't the exclusive consideration. We have the sentencing principles. I might just ask to turn to those. They are at page 870, behind tab 45.
Sorry, page again?
870.
Thank you.
So this is sentencing children and young people. Page 8, it starts at 868. And then you'll see the sentencing principles, paragraph 1.1 on page 870, when sentencing children or young people, those aged under 18 at the date of the finding of guilt, must have regard to, etc. The passage I would draw the court's attention to is page 893, crossing a significant age threshold between commission of offence and sentence. Does the court see that? 893.
893, just give me a moment.
I feel I missed the bit on 870.
I'm so sorry. 870 is paragraph 1.1. When sentencing children or young people, so those under 18 at the date of the finding of guilt, a court must have regard to...
Conviction, yeah.
Does your you'll see what's set out there.
Yes.
But then go through, please, to page 893, paragraph 6.1 and 6.2. There will be occasions when an increase in the age of a child or young person will result in the maximum sentence on the date of the finding of guilt being greater than that available the date on which the offence was committed. In such circumstances, the court should take as a starting point that the sentence likely to have been imposed on the date at which the offence was committed. This includes young people who attain the age of 18 between commission and finding of guilt. But when this occurs, the purpose of sentencing adult offenders has to be taken into account, which is punishment of offenders, reduction of crime. And you can compare those considerations when sentencing an adult compared to 1.1. So the date of the offence is not the exclusive consideration. Turning 18 has significance across the board in terms of the sentencing exercise and approach. Secondly, in terms of justification, the point I've already made, but falls here as well.
Remind me, what's the source or authority for this document?
The Sentencing Council guideline.
Thank you. Sentencing Council guidelines.
Sentencing Council guidelines.
That's right. We have that on page
Judges
868.
must have regard.
Which,
Yes.
yes.
Thank you.
Secondly, the point that I've already made, but it does fall here, the bright line at 18 has to be considered in a context where criminal law and practice offers no other opportunity for a minimum term review for any person who commits a serious offence, even as a child. See the discretionary life sentences, detention for life, and custody for life. Thirdly, we submit that notwithstanding that it's accepted that maturation continues beyond 18, it was also permissible for Parliament to proceed on the basis that adults, those aged 18 or over, do not go through the same accelerated development as children do. That's not to say maturation doesn't continue, rather it's not the same accelerated process. I think I need to deal here then with retrospectivity as a feature of the submissions under Article 14, which I think it's fair to record has grown somewhat in prominence as the proceedings have gone through the levels of the court. As an aspect of the Article 14 analysis, I have to come back to it at Article 7, we submit it faces a series of insuperable hurdles. But firstly, important to recognise Parliament did make provision for the implementation of its amendments on existing cases. That's 27B, subsection 3A, page 865 that we looked at earlier. Secondly, nothing in Hansard suggests, so I think has been floated along the way, that Parliament was somehow misled or didn't grapple with this issue. 27B makes that point, that there it is expressed on the face of the legislation how it will be applied. If there is, and I accept I have to make this good, but if there is no Article 5 violation nor any Article 7 violation, then it's very difficult, we would submit, to contend that the appellant has lost any substantive right that is in play. Instead, properly analysed, there was only an opportunity to apply for the exercise of executive clemency, which might lead to the reduction in minimum term. There was no express commitment to this appellant from the Secretary of State or officials that he would be able to make such an application. He didn't receive a letter because he wasn't approaching the halfway point. And of course, any legitimate expectation submission has to accept that the Secretary of State's policy could change, as indeed it did in February 21. But I do submit that it is difficult to see how the retrospective points fall within the structure of an Article 14 submission, because it's difficult to see how the implementation of this measure might make what was otherwise proportionate disproportionate. It would also be, if the court would going to go down this route, it would obviously be extremely important to know whether this was a finding that went against the whole of 27A, 1 and 11, which is how the claim was originally put, or in fact it's only a finding of incompatibility when considered against the cohort of those who had already been sentenced, so it's only on a retrospectivity basis. But if we're doing it on a retrospectivity basis, just considering conceptually what we have under Article 14 and the proportionality balance, we still have, on the one side, the victims' families and their interests. Their interests, we would submit, are undiminished and unaffected by the fact that the sentence has already been imposed. And on the other, all that my learned friend can point to at most is the loss of an opportunity for a review that might lead to a reduction in minimum term. But in circumstances where we would submit there is no substantive right that's been lost, particularly if this court finds, as the lower courts did, that there is no Article 7 issue.
And I think it was inherent in what you said about policies can change, that it's loss of an opportunity for a review, which itself might be taken away as a matter of change of policy by the Secretary of State.
Exactly.
So it's a very long way away from any sort of right that the person could bank upon.
Precisely, yes. And I think it's fair also to note, if you were to go back to the sentencing comments made by His Honour Judge Holt, that there is no suggestion there that this is a provisional sentence that's been imposed. It's a minimum term that has been fixed by the court. And it's made clear that's not to say you'll be released after the expiry of that minimum term, but that's the point at which the parole board can consider your case. So that is the first exhibit to Mr. Webster's statement.
Do you have a page number for it?
Yes,
Sorry?
445. Sorry, page 445.
I think Mr. Fitzgerald was making the point that if you're looking as to what is a fair balance, prospectively removing a right so that it beds in over a period of time is one of the factors you take into account. And the converse of that, the other side of that coin, is retrospective removal of a right is something that you consider in balancing fairness. What do you say to those problems?
Well, my Lord, yes, I struggle genuinely to see how that fits within the Article 14 balance, and I can't see any authority that supports that approach. Yeah. We've referred in our case to the decision in Akbar that we have in the bundle, page 1008, but I have to accept it's only by analogy, and it's considerably removed from the facts of this case. But the issue must but there's a finding there that in that context, a reference to the Secretary of State removing a discretion that he formerly had was irrelevant to the Article 14 analysis. You just looked at the provisions on their face and asked the question, is this proportionate or not?
I mean, is there anything more in the point than, as I think my Lord was putting to you, that it may feel more unfair to remove a benefit
or an opportunity
someone already has,
yes,
than to introduce a completely new system which in itself has distinctions which are there. And if it does feel more unfair, one might think that it's at least capable of being a factor that feeds into the fair balance assessment at the end of the proportionality.
Yes, my Lord, and
I understand you're saying it's a small thing. It's not a major right being taken away from someone that they'd have structured their lives around, thinking, well, I've got this right, and
absolutely, and I think
accordingly.
I entirely agree, my Lord, and I think that it may be that the sort of more structured analysis we see in Articles 5, foreseeability, and Article 7, retrospective increase in penalty, in that you have to ask, particularly under foreseeability, you have to ask the question, well, what could you properly be, we're going to come to it under Article 5, but what could you properly have been advised of at the time?
Yeah.
The advice at the time would have to be, this is being offered to you or provided to you by the Home Secretary as a matter of policy. The policy could change, and you need to be aware of that. And so to the extent that I can't dispute that there is some aspect of a sense of unfairness, but the submission is it doesn't make a difference to that balancing exercise where you've got victims, families' interests on the one hand, and then the offenders on the other. And, perhaps importantly, Parliament has itself considered how it's going to implement these issues.
I understand all of that. I was really just taking issue with where you said you struggled to see how the point of retrospectivity fitted into an Article 14
yes, and I think it can
analysis. And I think you are accepting that it's a potential relevant factor at the fair balance stage, but you say it's actually in context of quite minor weight in the current context.
I think I have to do that. Yes.
And also you would accept that, I think you can test whether there was one, that a legitimate expectation should also be taken into account in considering fairness, overall fairness. So if there is a genuine, a reliable expectation, that also should be taken into account.
I'll come back to the court after lunch if on reflection I think I'm going too far, but I think I do have to accept that.
Yeah.
Yes. Yeah. On the basis that it is a balancing exercise and you've got the offender's interests on one side, and those, I think we have to grapple with the substance of those interests. So, my lords and my lady, that is, I think, what I need to say on the details of Article 14. We would ultimately rely on the key points being that Parliament has considered the very proposition which is being urged here, and then consistent with the proper wide margin of appreciation that applies here, we respectfully submit that the only appropriate endpoint of the fair balance is to decide that this was proportionate and in pursuit of legitimate aim.
Yes.
So, Article 5, then. Yep. The short points here, we submit, this is our case paragraphs 81 to 92, pages 96 to 98, that the Court of Appeal's analysis here is unassailable. That's its decision, paragraphs 84 to 85 on page 149. The short points are that while a prisoner is serving their minimum term in the context of a sentence of DHMP, no issue as to the lawfulness of the detention can arise under Article 5.1. That's during their minimum term. And Article 5 doesn't impose any obligation to offer an opportunity to apply for a review of that minimum term. On no Article 5 issue arises while within the scope of the minimum term. We take that from Brown, that we have at page 925 is the key conclusion at paragraph 39. Only after the tariff has expired that any question can arise as to whether the continued detention is arbitrary and therefore not lawful within the meaning of Article 5.1a. Secondly, as I say, Article 5 doesn't impose any obligation to offer an opportunity to apply for a review of a tariff or minimum term. I think this is properly characterised as a new point on Article 5 foreseeability, but the answer to it we submit is in Morgan, pages 997 to 998, paragraphs 121 to 129. This is the decision of my Lord Stevens.
Sorry, just to assist me, you say point on foreseeability is a new point. Where in the appellant's case is it set out, just so that I can have a note of that? Do you happen to know?
I don't.
Right. If you can't assist us now, you can give us the reference later on.
Certainly.
Anyway, it's dealt with in Morgan at paragraph
121 to 129, pages 997 to 998 behind tab 50. So this is the qualitative requirements under Article 5, and they are different, Article 5 requirements to Article 7. We'll come to Article 7 in due course. Paragraph 121, page 997, it introduces the issue and draws the distinction between the requirements in respect of law, inverted commas, under Article 7. That applies, of course, to the offence with which the offender is charged and the penalty. By contrast, the qualitative requirements in respect of law in Article 5 applies to the resulting detention. Measures relating to the execution of a sentence can affect the right to liberty protected by Article 5. Accordingly, the distinction between penalty and execution is not necessarily decisive with respect to Article 5(1)(a). That's, of course, a distinction with Article 7. 123, paragraph 123, page 997, that the change in the regime for the release on licence of the respondents met the qualitative requirements in respect of their detention, qualitative requirements of lawfulness under Article 5(1)(a). For these reasons, and we would draw the analogy of each of these reasons with the circumstances before the court now. Firstly, paragraph 124, page 997, the term of the sentences imposed on the respondents were calculated without account being taken of the early release provisions under Articles 8 and 17 of the 2008 order. Similarly, we submit the minimum term here set by the judge was reached without any reference to any potential review, availability or otherwise. Secondly, the lawfulness of the respondent's detention was decided for the duration of the whole sentence by the determinate custodial sentence imposed by Colton J. We would say, similarly, no issue as to arbitrariness or lawfulness can, on any view, arise during the minimum term. 3, paragraph 126, the fact that the respondents expected to be released on licence at the halfway point does not affect the analysis that the determinate provide legal authority for their detention throughout the terms of the sentence. Well, our position here is, of course, much stronger than that, we submit, because there was no suggestion that that there would be an expectation of a reduction of the minimum term. It's the opposite. The anticipation is that the minimum term will remain, subject only to an application being made and then a further decision. Fourthly, paragraph 127, it's entirely foreseeable, if necessary with appropriate legal advice, that during the currency of a determinate custodial sentence which is calculated and imposed without account being taken of the possibility of early release, the arrangements for the manner of execution might be changed by policy or legislation. And we have the parallel here. We submit, when you're relying on a Secretary of State's policy applied to the possibility of seeking a reduction of the minimum term, you have to recognise that the policy can change, and indeed it did change in February 2021. So we submit that, by analogy, that same analysis is a fortiori here, and is the full, and we submit complete answer to the Article 5 foreseeability challenge. Article 7, unless there's more I can say on that. Article 7?
Yes, Article 7, thank you.
We submit the Divisional Court was right to find no merit in this ground, described as something of a make-weight, and the Court of Appeal right to dismiss the appellant's cross-appeal. Again, we submit no basis to question or criticise the Court of Appeal's analysis from paragraphs 101 to 2, and we invite the Court to, starts at page 155, and we've set this out in our case at paragraphs 93 to 102. The single issue here is whether the absence of the former possibility of making an application to reduce the minimum term has increased the penalty of DHMP. We submit that losing the opportunity to reduce a penalty cannot be equated with the imposition of a heavier penalty. We would, if necessary, go back to Morgan and the analysis starting at paragraph 76 and following. I think the key passages are at 85. So, page 987, paragraph 78, concept of penalty and its scope. And then 85, consideration of the ECHR case law in Hogburn. And by parity of analysis, the sentence in Hogburn's case was life imprisonment. We would submit that the sentence here is detention at His Majesty's pleasure, which plainly hasn't changed, but moreover...
It's a detention at His Majesty's pleasure plus a minimum term, plus an ability to apply for parole, plus where the person is detained being at the discretion of the Secretary of State. There are a whole lot of components of the sentence.
Yeah, my Lord, I agree. But and moreover, though, the key feature in terms of penalty we submit is the minimum term that has been set by the court. So even if you're not prepared to accept that its DHMP can be equivalent to other life sentences, it crystallises, the penalty crystallises in the minimum term. And if there were to be an increase in the minimum term, we respectfully submit it would be very difficult to sustain the proposition that there hasn't been an increase in penalty in substance. But of course, that isn't what is in issue here. There's been no change to the minimum term whatsoever. No equivalence we submit can be drawn therefore with Del Rio Prada, because again, the substance of the effects of the changes in that case were completely different and undoubtedly retroactively increased the sentence following the application of the parole doctrine. And where we end, I think, my lords and my lady, is in the submission that Kopinski affords some answer here or some assistance here, on the basis that in Kopinski a reducible life sentence was converted to an irreducible life sentence, and we have here a reducible minimum term, which has become an irreducible minimum term. With respect, that is a linguistic argument we submit, and not a legal one. Kopinski, the issue in Kopinski, it might be helpful to go to it at page 1780, tab 76. Tab 76, page 1780, and in particular paragraphs 51, 52 and 56. Which are through on page 1780. The distinction there was that, and the facts are set out, 51 and 52, that an irreducible life sentence is effectively the equivalent of a whole life order, i.e. there is no prospect of release at all. That is, we submit of a completely different order to a minimum term. So that was converted, a 20-year minimum term, essentially converted to a whole life order in Kopinski. That's the substance of what actually happened. The change effected by Section 27A, of course, leaves the minimum term that the appellant will serve exactly where it was. All that has been lost, in inverted commas, is the opportunity to make a request which may or may not lead to a minimum term reduction. We were provided by the court helpfully with MA, and
just before we leave Kopinski, I think perhaps the last part of paragraph 51 is of some significance. The court observes that, as can be seen from the relevant provisions of the Hungarian legislation, it differentiates between reducible and irreducible life sentences and provides for both. In the applicant's case, the domestic courts in Hungary had explicitly decided to impose on him a reducible life sentence.
Yes,
so
exactly. They've taken a choice.
What order the court itself had made, and it had imposed a reducible sentence, but the effect of the change was to
the effect of the transfer, exactly, to a new jurisdiction was what you get a whole life order. Yes.
Yes, thank you. Sorry, you were taking...
Sorry, so then MA, the second judgment we were provided with yesterday, I think paragraph 29 is the key one. Because the focus is the distinction between the execution of the sentence and the scope of the penalty. So a measure relating to the execution of a sentence will, it's internal 102, 103 up
Yes.
I know that's not very helpful.
Sorry,
On a
it's paragraph
PDF.
29, did you say?
29 is page
29.
28 of the edit.
28 of the electronic.
Thank you. Page 28. So the distinction being drawn, consistent with Morgan, is between the penalty and those matters relating to the execution of it. A measure relating to the execution of a sentence will be incompatible with the second sentence of 49(1) only if it retroactively alters the actual scope of the penalty, provided for on the date on which the offence at issue was allegedly committed, thus entailing the imposition of a heavier penalty than the one initially provided for. That is not in any event the case where that measure merely delays the eligibility threshold for release. The position may be different if the measure essentially repeals the possibility of release on licence, or it forms a series of measures which have the effect of increasing the intrinsic seriousness of the sentence initially provided for. And my submission is that that is looking at the substance of the penalty actually imposed and experienced, and it would be engaged if we were in territory where the minimum term were increased after the event.
It's also perhaps relevant to observe paragraph 28. The court has referred to Kopinski as well.
Yes. Yes.
So what it's stating there, it regards as compatible with what was said in Kopinski.
Exactly. So we do submit that what was lost here was a contingent opportunity to seek to reduce the minimum term. And there is no arguable basis to contend that a heavier penalty has been imposed on the appellant and the one that was applicable at the time that the offence was committed. Finally, on foreseeability within Article 7.
Just before leaving that, you accept that that was the retrospective effect of the change of the policy and the legislation, that the contingent opportunity to seek to reduce the minimum term was removed.
Yes, I have to accept that, yes. Yeah. And
The contingent opportunity was one that rested in policy rather than...
exactly.
Right.
Yes, exactly.
Yes.
So in fact, it could have been changed by a change in policy.
Well, and it was changed. That's the February 21
Yes.
point, that it was changed by policy.
And in fact, that would be entirely consistent with the Act of Clemency, because that
Yes.
rests upon a discretionary exercise with policy considerations coming into account.
And that's how the Court of Appeal, I think, landed there at paragraph 43 of their judgment, when asking the question, what was the power being exercised by the Secretary of State during that interim period? Sorry.
My Lord Stevens put yesterday to your opponent the question whether the fact that all the matters which would feed into a half-term or thereafter review would, under the existing three tests, would be entirely or almost entirely matters arising after the passing of the original sentence, was relevant to the distinction between, if you like, execution on the one hand,
Yes.
alteration on the other.
Yes. And
Do you want to say anything about that?
so I agree that is the focus of the issue. The focus is on essentially rehabilitation and progress, exceptional progress, being the threshold test of the offender post the imposition of the minimum term. I accept it's not exclusively about that.
Well, I was just wondering about that, because the other factors, another factor is whether further information has emerged which
is why I'm being careful about.
but that factor originated at a stage where there wasn't an appeal against the minimum term, as I understand it.
Yes. Operate as a matter of policy.
It operates as a matter of policy. Therefore, you couldn't have an appeal at a time in relation to it.
Yes.
And I just wonder about whether that factor is really consistent with the ability of the courts to adjust the minimum term by an appeal process.
Well, my Lord, I think it is the frank answer, page 447, which is the criteria that were applied. The first two very obviously go only to the matters post-sentence and the concern with the offender. So page 447.
Yeah.
exceptional progress in prison, risk to the detainee's continued development, cannot be significantly mitigated or removed in the custodial, and then any matter that calls into question the basis of the original decision to set them into
Well, that's clearly wrong, isn't it?
And I think that's the problematic aspect of it.
Well,
yes. Yeah.
I mean, how could the Secretary of State operate an appeal process? I just have difficulty in understanding how that particular factor was lawful.
Yes,
and how somebody hadn't caught on to the idea that the whole process had been judicialised and there was an appeal process.
Yes.
So, anyway.
Yeah. I don't think I can assist, I'm afraid, on that. But we do submit that for the purposes of Article 7,
yes,
the focus was on progress civis
yeah.
and a point of execution of penalty. Then I think the only further point I needed to deal with was just very briefly on foreseeability under Article 7, which, as I read Morgan, is in fact coterminous with the issue of penalty. So if Morgan, page 993.
993.
993.
Thank you.
Tab 50. So paragraph 104. So this is the discussion analysis, my Lord Stevens, begins page 992, paragraph 98, goes on to page 993, and then, but it's the two propositions. 104.1. First, where a measure relates to the execution or enforcement of a penalty, it doesn't fall within the concept of law in Article 7, and the requirements of foreseeability do not apply. Secondly, wherever a measure relates to a change in the penalty, and as such falls within Article 7, any such changes fall within the scope of law within including foreseeability. So my submission is if you're not in penalty, you don't, there's no question of foreseeability. And so foreseeability doesn't add anything to my learned friend's position under Article 7.
And your general submission is that this is all about Lord Stevens' first point, and we don't get to the second one.
Exactly.
And I think, insofar as reference was made to the foreseeability section in Rio del Prado,
yes,
that was addressing what is the scope of the penalty that was initially imposed, because in some systems the penalty might be subject to a degree of expansion,
yes,
compatibly with the concept of law.
yes.
But we're not concerned with that dimension of the case at all here.
That's exactly right.
All right, I just wanted to check that that's what you meant. Yes.
So, unless there are any other matters I can assist the court with.
No, thank you very much.
Thank you very much.
Yes, Mr. Fitzgerald.
Thank you, my lord.
So I think by my count we've got 27 minutes.
Yes. Thank you.
Since I am keeping count.
I may have
But I'm sure that
I may have trouble filling
plenty
it.
for
Let's just start with my learned friend.
I'm sorry to interrupt you right at the very start.
No,
Do you accept the protection of victims' families is a legitimate aim?
Yes.
Right. And do you also accept that a bright line should be fixed? Because it obviously, the bright line should either be 26 or 18. And so you accept a bright line.
On careful consideration of that, I don't accept that.
Right.
Because, my lord...
A 45-year-old offender
Yes,
should have an ability to review. Is that right?
Well, my lord, what I'm saying is that anybody who has this sentence should be considered for review, but obviously it's very unlikely, and that's catered for in the statute because the Secretary of State.
That's a review without any ability to actually carry it out at all. That's admitting of a possibility that will never actually happen in reality.
Well, my Lord, the only reason I say that is because the logic of my case,
Yes.
as I hope your Lordship appreciates, is that it flows from the unique nature of the sentence. I would not want to exclude the possibility that there are cases where the person supposing they committed the offence when they were 12 and they're now 45,
Yes.
where you would want to consider progress. The reason, my Lord, the reason I say that it's almost academic is because in that case, the judge who sentenced the person at 45 will take into account all the progress. So it's so unlikely that there will be any basis for there to be a further review of how they've changed between the age of 12 and 45. The Secretary of State would just say this is frivolous. But that's in our submission, the basic principle is that the right to apply for a review flows from the nature of the sentence. My Lord, it's right that I think in the Court of Appeal I accepted that there would be a justification for drawing the line at 26. My Lord, I think it's recorded. My learned friend refers to it, and my Lord, that certainly would be my fallback position. What was it? No, I think it's Court of Appeal. Anyway, when pressed. But my Lord, what we respectfully submit is that this is a unique sentence. My learned friend said it's a unique sentence because it's based on the age at the time of the offence. Of course, the court will appreciate that was because it started off as an alternative to the death penalty. And that's the reason. In lieu thereof, shall not be sentenced to the death penalty, in lieu thereof, will have detention during Her Majesty's pleasure. Detention during Her Majesty's pleasure had a significance. That is to say, essentially not exclusively retributive at any rate. Trial of lunatics was also the sentence proposed for recidivist habitual offenders in 1910. And there was a great speech by Winston Churchill saying, we can't have them detained during Her Majesty's pleasure, there must be some limit. But that's the concept. The concept is of indeterminacy requiring a review. And that concept has not gone in our respectful submission because the sentence has now got this judicialised component. And so, my Lords and my Lady, we say the review is a consequence, the need for a review is a consequence of the unique sentence. From the moment it's imposed, it is not altered and has not been altered by the introduction of a judicialised tariff. I know that the court has the passage, paragraph 11 of Lord Bingham, saying that the same principle should apply even where it's judicially fixed, and then paragraph 25, Baroness Hale, saying, I don't see why there should be any difference when it's judicialised. It's true, I accept that the ratio of the case was confined to the pre-2000 Act, but the underlying reasoning is that there should be a right to review in all cases. So my learned friend said there's no principled objection to determining the availability of review by reference to age at the time of sentence. Well, that there is a principled objection, which is that, first of all, the sentence itself is premised on age at the time of the offence. It's premised on that for very good reason, which Lord Bingham explains in Smith. And underlying that was the unavailability of the death penalty, and that has been consistently the approach in relation to the availability of the death penalty since 1948, and it's now reflected in countless international provisions that neither death penalty or life without parole should be imposed on people who are convicted of an offence that they committed when they were underage, at the age of 18. So there is a serious norm underpinning the fact that this unique sentence is applied on the basis of your age at the time of the offence. And our simple proposition in terms of the legitimate aim is we say, of course, it is a legitimate aim to limit distress to the families of the victim, but it should not be achieved by fixing the bright line by reference to age at the time of sentence, but rather it should be available on the basis of age at the time of the offence, as indeed the sentence is. And my learned friend then went through the exercise.
But how do you in any way limit victim distress caused by the fact that a DHMP is inherently reviewable by saying, well, that distress should be ameliorated by using age at the time of the offence? I mean, it doesn't achieve any amelioration at all, does it?
Well, my lord, if one says what is the vice, my learned friend said, if you want to look at what was being addressed,
yeah,
you look at the white paper, and I've made the point, but I make it again. 6 times in those 5 paragraphs, they refer to the vice being continuous review. Their recommendation was not remove all reviews, but remove continuous reviews. It wasn't even contemplated at the time of the white paper, which is the only carefully considered consideration of this matter. It wasn't even contemplated that there would be removal of all reviews. It was just, we'll remove continuous reviews because that's what causes the real distress. That is, if you're saying we'll look at the white paper to identify the mischief they identified over and over again was subsequent reviews, continuous reviews, repeated reviews.
Well, I'm not sure that is a fair characterisation of the white paper. As Mr. Watson pointed out, paragraph 328, page 555, the point is being made, 555, the point is being made that it's the existence of the review procedure, particularly opportunity for continuing reviews, but also the first review can be extremely distressing.
Well, at page 555,
yes,
the existence of an important part of ensuring existence of the review, particularly the opportunity to continue after the halfway, can be extremely distressing.
So that clearly comprehends the first review.
Yes, but if one reads on, well, I've made the point, yes. But if one does read on, it's.
But anyway, it doesn't matter very much because what we're concerned about is Parliament's reason for acting.
Well, yes.
So Parliament clearly has cut off the scope for review in our class of case.
Yes. Well,
knowing that the basic objective that it has been identified for a move of that kind is alleviating distress to the families of victims.
Yes. Well, my lord, all I can say in relation to that is that we invite the court to take the approach of close scrutiny. That's the approach that was adopted in Clift because of the risk of arbitrariness. But even applying a wide margin of appreciation, the divisional court came to the conclusion that it was not a fair balance and was disproportionate. And in relation to that disproportionality, my lords, my lady, we say that really the Court of Appeal completely minimised the level of frustration of a legitimate expectation. There had been, since the Smith decision, and indeed before that, after the Venables decision, a policy of continuing a review. That continuing review was limited to only a review at the halfway point, if that, under the policy that you've seen in 2010, and then further limited by the proposal of no reviews for those over 18. But we do submit that if you look at the impact on there had been a settled policy of monitoring by the prison staff with repeated reviews, with repeated reports, building to a halfway point application, which was developed through a very formalised system of judicial consideration of whether there should be a reduction, resulting in many cases, and you've got the Annex A in the Court of Appeal, to reductions in many cases. It is, in our respectful submission, and I fear it either, as it were, the court either instinctively accepts this or rejects it, is just that it's grossly disproportionate to remove that review on which people had counted, on which they, and there's evidence that he counted on it, there's plenty of evidence of other prisoners relying on it. It may stand to reason that they relied on it. And in some cases had relied on it for 5 or 10 years. And then it's removed. And, my lords and my lady, we say it's removed retrospectively. It's quite true, my London friend's right to say that there was consideration of those who had already reached the halfway point, and that was dealt with. But what wasn't addressed at all, and indeed, my London friend doesn't dispute that, is those who were sentenced as this person in 2015 for many years had built their expectations on the basis of a review, and then they had that removed. And we do respectfully submit it would have been it was inconsistent with the nature of the sentence that was imposed on him, but it was also disproportionate to the achievement of the limitation of some distress. My lords, that's the basis on which we put it, and it does go to the question of fair balance. And in looking at the fair balance, we do respectfully submit that if there is a spectrum ranging from matters of penal policy, such as allocation to a particular type of prison, or prison conditions where issues of resources and judgment by Parliament are obviously crucial, to a question of this which is connected not just with the administration of justice, but with retrospectivity in the case of this appellant, on which the courts are, if I can put it, well able to examine whether it's a fair or just balance, because it's, as it were, home ground, the question of retrospective removal of something that the person has built their whole expectations on. That is something where the court can, with confidence, say that was disproportionate, unless it's clear that Parliament considered it. And there's no evidence that they considered people in the position of the appellant. So those are my submissions, my Lord, in relation to that. I think I've made my submissions in relation to, we say this is a Clift case, not a stop case, and that the risk of arbitrariness does arise in this case. I've made my submissions as to what the true mischief was, and in relation to Hansard, we accept that there was an amendment considered and rejected in relation to raising the age to 26, but we do point to the glaring omission of the consideration of retrospectivity in this regard. We say that 27B 3A does not mitigate that. So our respectful submission is there was no fair balance achieved. My Lord, my Lady, in relation to Article 5, we do stand by the submission which really is best made in the case at so sorry if I can just, yes, paragraph 81, that's to say at page 53, this is a causal link between the imposition of the sentence and the continued detention can be broken where the detention becomes inconsistent with the objectives of the sentencing court. And we say that the sentence pronounced by the sentencing court is detention during Her Majesty's pleasure with the special rationale identified by the House of Lords in Venables, by the House of Lords in Smith, and essentially acknowledged by Parliament itself.
But sorry, the sentence is imposed includes the minimum term, which is imposed for the purposes of retribution.
Yes.
So serving the minimum term remains compatible with the object of the sentence, which is that you should serve that period as part of the retribution part of the sentence.
Yes. Well, my Lord, obviously our submission is that one has to refine the description of the sentence.
Yes.
To say that actually the sentence was to a reducible term and one acknowledged to be capable of reduction. That's why we submit, in line with paragraph 81 of the case, that this did lead to arbitrary detention because it was detention inconsistent with the unique rationale of the sentence. And then, my Lords and my Lady, finally, Article 7. And in relation to Article 7, we stand by our submission that what was done was to turn that reducible minimum term into an irreducible minimum term. So whilst accepting that it should be reducible for all the others, it was turned into an irreducible minimum term for those sentenced after the age of 18. And we say that does result in a different sentence, an amended sentence, a redefined sentence that is contrary to Article 7. Well, as I can just...
No, thank you very much, Mr. Fitzgerald. The Court is grateful to Council for their oral submissions and for their written submissions. We're also grateful to those who have helped in the preparation of the case for our consideration. You've given us a lot to think about. We will reserve our judgment. This hearing is now adjourned. Thank you very much.